So I'm going to focus on the legal aspects of futility in the ICU. I have nothing to disclose. So as Dee explained in her presentation, most futility disputes can be prevented, and most of the ones that do arise can be resolved, and consensus can be reached. So I'm going to be focusing down here at the bottom of the funnel on the intractable futility conflicts. And there's basically four pathways that an intractable conflict can take. The clinician can take covert action. You cave into the surrogate demand if you feel appropriate. You can take unilateral action to stop without consent, or you can get a new surrogate. So covert action, right? Without legal support to withdraw or withhold openly and transparently, some do it covertly. There's a number of studies, but what's still the most widely cited study for this by Ash, 14% of responding physicians reported that they not only withheld without consent, but also without the knowledge of the family or surrogate. The more common approach is to just cave in, right? And so even though they feel that the requested treatment is medically and ethically inappropriate, a lot of physicians go ahead and provide the treatment that the substitute decision maker is asking for. Why? The most common reason for why you do that is a lack of legal support. There's an implicit or explicit threat of some legal action. And while the risk is actually pretty remote, clinicians aren't just liability averse, they're litigation averse, right? Even prevailing parties pay transaction costs in terms of time, emotional energy, and so forth. So I want to move on to the third dispute resolution pathway, which is taking unilateral action, right? What I mean by that is you're withholding, withdrawing without consent. And in summarizing the legal landscape in the United States, I like to use the metaphor of a traffic light, red, green, yellow. And so the attraction of Texas, just to transition from the last talk, is that what Texas does is it provides a green light, right? It tells the clinician, go ahead, do what you think is appropriate, and you're safe. You have complete civil, criminal, disciplinary immunity. And the Texas law has been used quite a bit in the last 14 years, often even in the face of intense media scrutiny. Indeed, a number of other states have looked to Texas as a model, right? And they've tried to copy it in their own states, right? You have medical associations in California passing resolutions to help the Texas law, in Washington, in Wisconsin, and in fact, more formal action has been taken in all three branches of state government. So just by way of example, the Idaho Senate in 2009 passed a bill modeled and copied completely from the Texas Advanced Directives Act. In Maryland, they tried to do the same thing, but through agency regulations instead of the legislature. And in New Jersey, the Hospital Association and the Medical Society asked the courts for a Texas-type rule. Now, all of these efforts actually never panned out, and none of them were successful, so Texas basically remains alone. Now, while seen as a model, I think there's some problems with the Texas approach. Now, to be sure, when you can't agree on substantive criteria, and we can't, and haven't been able to come up with any, other than maybe anencephaly and brain death, then the best you can do is to have a process, a pure procedural process. But if process is all you have, right, because there's no criteria built into Texas Directives Act, whatever the clinician thinks is his or her reason to determine that the treatment request is inappropriate, there's no constraints on that. But if process is all you have, it has to have integrity and fairness. And there's a number of traditional elements of procedural due process, right? Notice, the opportunity to present, the opportunity to confront, having an independent individual decision maker, getting a written statement of decision, and the opportunity for judicial review, right? If any action were taken against the license of anybody in this room, or staff privileges of the defendant's group and be entitled to all of these elements of due process before that was taken away from you. It's not clear that any of these elements of due process adequately obtained with respect to the Texas Advanced Directives Act. And we don't have time to go through all of them, but what's traditionally considered to be the most important aspect of due process is having a neutral and independent decision maker. And as you even saw from the Memorial Hermit, right, the 7 people on the mark are all insiders, right? The 4 physicians and 3 nurses, right? And in fact, one study of Texas ethics committees shows that most of them are pretty small. About half only have 1 to 5 members, and about another half only have 5 to 10 members. It's mostly, again, comprised of physicians, nurses, and administrators at the hospital. There's no community member requirement built into the Texas Advanced Directives Act, like there is for IRBs. And in fact, less than 10% of Texas ethics committees have an outside independent community member who doesn't work for its financially dependent upon the hospital. Now, in the 2007, 2009, 2011, and just more recently 2013 legislative sessions in Texas, they've actually tried to improve due process aspects, giving more than 48 hours notice and so forth. But those bills have failed year after year after year, and so the Texas Advanced Directives Act is the same as it was. It's the right concept. It just could be better. Now, Texas isn't alone. There are other, what I'm calling green lights. One is many states have been enacting more conscience laws in legislation, right? So these laws basically say, not for professional reasons like the Texas Advanced Directives Act, but for personal moral reasons, you can refuse to provide requested treatment. These laws have usually been conditioned on the fact that you can't stop until you find a replacement for yourself, so the so-called treat-till transfer conditions. But increasingly, the conscience clauses haven't had that condition. For a long time, Mississippi hasn't had that. So you don't have to treat-till transfer, you can just stop. And now, more recently, Nebraska, Michigan, and Kentucky have now enacted conscience clauses that aren't conditioned on treat-till transfer. And other states like Oklahoma have been considering these broader conscience clauses. And then finally, I just want to mention a third green light in the United States with respect to futility. Normally, in a pulsed, you need to get patient or surrogate consent for the orders that have been pulsed. But in Maryland and in Vermont, the pulses allow the clinician to write a DNR order without consent. They explicitly say this can be written on the basis of futility instead of on the basis of consent. So I just want to transition from green lights to red lights. Right? The red light basically says to the clinician, you cannot withhold or withdraw life-sustaining treatment unless you have consent. Right? So in New York, for example, the Family Health Care Decisions Act says if the surrogate directs life-sustaining treatment that the provider does not wish to provide, the provider shall nonetheless apply. In Idaho, last year they passed a law called the Discrimination in Denial of Life-Preserving Treatment Act, which says healthcare may not be denied if it's directed by the surrogate. In Oklahoma, just this year passed a bill very similar to that. And other states like Alaska have been considering such red light bills. So there's one specific red light that I want to take a second to mention to you, and that's Ontario. So 12 days ago, the Supreme Court of Canada decided a case called the Surrogates case, which basically made Ontario a red light jurisdiction. So Hassan Rassouli has been in a Toronto hospital for actually as of the last 3 years in this hospital, and he had a brain tumor operation, but then he had an infection which put him into a persistent vegetative state, although that was later upgraded to a minimal unconscious state. His clinicians thought that the continued treatment could offer him no medical benefit and wanted to withhold the mechanical ventilation on which he was dependent. The family, however, would not consent, so the clinicians proposed to go ahead and withdraw without their consent. The family went to the Ontario Court of Justice, which ordered the clinicians to continue. The Ontario Court of Appeals affirmed that. 12 days ago, the Supreme Court of Canada issued a rule that says always need consent for withdrawal. Now, of course, the very nature of medical futility dispute implies that you're not getting consent from the surrogate. That doesn't mean that you're stuck. It doesn't mean you're stuck in Canada. It doesn't mean you're stuck in any other red light jurisdiction. Because if you can't get consent from the currently authorized surrogate, maybe you can get a new surrogate who will give you consent. And so, in fact, Ontario has a special tribunal called the Consent and Capacity Board, the CCB, which does just this, right? If you think that the surrogate is not making appropriate decisions for the patient, they either direct the surrogate to make the appropriate decision or appoint a new surrogate. Right? The surrogate is supposed to be making, this is true in every U.S. jurisdiction as well as Ontario, supposed to be making treatment decisions that are in accord with the patient's wishes, and if you don't know what those are, at least in accord with objective best interests. If a surrogate persists in refusing to comply with those decision-making standards, they can and should be replaced with surrogate. And in fact, we know from dozens of studies now that surrogates have pretty low accuracy rate in terms of making the same treatment decision that the patient would have made for herself. And in fact, all that inaccuracy means one way in favor that surrogates make more aggressive treatment decisions than patients would make themselves. So let me just move back from Ontario back to the United States. Right? In the United States, even though we don't have a special consent and capacity board tribunal, surrogates in futility disputes are replaced all the time by courts, and even at the institutional level. Right? The obvious easy cases are when the surrogate has a material conflict of interest, or even where the surrogate is asking for something that contradicts the express terms of the patient's directive. In a case like that in Minnesota, Albarn's had a directive clearly refusing treatment applicable to his circumstance. His wife, however, was asking for that treatment. She was replaced with a professional guardian by the probate court. Same thing in New York case. Even in the tougher situation where you don't have a contradiction between an advance directive and the surrogate's instructions, or where there's that contradiction between best interest and a surrogate, the courts have replaced the surrogate. So in the New York case, this patient's wife was replaced because the court explained she failed to follow medical advice and failed to use judgment. And in the Mass General, Barbara was replaced as a surrogate for her mother because the court found that her own personal issues were impacting the decisions and urged her to refocus her assessment. I just might flag that this is not just surrogate replacement is not just an option, but it's probably also, if you think the surrogate is really not making the correct decisions, you really should replace them. So this is the option. Red light jurisdictions is an option in every jurisdiction. But there's some limitations to this. One is it's often difficult to show a deviation between what the surrogate is asking for the patient's wishes or best interests is. Because we often don't have enough evidence about patient wishes. As you saw, none of the patients who were born affirming had an advance directive, so it's hard to establish the contradiction that you might need to replace the surrogate. Second, surrogates get the benefit of the doubt, so it's fine. You might need to show contradiction, sharper contradiction to justify replacing the surrogate. And then third, surrogates are actually faithful, right? So take the Rasuli case, right? The reason that his family then wanted to consent to the treatment plan was because of his Muslim faith, right? In other words, they were being good surrogates, faithful and loyal surrogates, making the same treatment decision that the patient would have made for himself. There's no basis to replace them. They're doing their job exactly as they're supposed to be doing as surrogates. And this is actually a big issue because religion is a big cause for most intractable conflicts. It's precisely in those cases that surrogate replacement, surrogate selection is not taken by precaution. So what you have basically are irreplaceable surrogates. So let me just finish this section. That means, now the good news is that there's only a handful of red light jurisdictions, just as there's only one green light jurisdiction. So most of the United States is what you might call yellow light, right? It's just not clear what the rights and obligations are of the clinician to unilaterally stop life-sustaining treatment of the surrogate, an irreplaceable surrogate is asking for, right? Most of these states actually purport to provide the safe harbor legal immunity, saying, hey, clinician, you don't need to provide treatment that the surrogate is asking you for if it is, quote, contrary to generally accepted healthcare standards. Not a really good safe harbor because there's so much variability in end-of-life medicine that it's not really clear if there are any generally accepted healthcare standards, so it's not quite clear where the boundaries are of the safe harbor, so you don't know where you need to be safe inside the safe harbor. They need safe harbors to work effectively, to be clear, precise, concrete, and certain. These ones are not. Right? This is not a safe harbor. This is mind harbor. And therefore, because of legal risk averseness, clinicians are chilled from providing the medical treatment that they think is ethically and medically appropriate. Actually, worse, by continuing to provide the very treatment that they think is medically appropriate, they're actually continuing to create and reinforce the very standard of care with which they do not want to comply. Or, in other words, because of legal risk averseness, yellow lights are basically perceived to be effectively the same as a red light. I think that's changing a little tiny bit, such that there's a little bit of work to convert yellow lights into green lights. What I mean by that is some professional associations, like the Renal Physicians Association, are refining their guidelines to be a little bit stronger, for example, about dialysis with meditating patients. So I think as the practice guidelines are getting a little bit more precise, a little bit stronger, those yellow lights, at least in some circumstances, might go back into green lights. Thank you.